In this lecture, we're going to be covering chapters 40 through 45. Chapter 40, Bankruptcy. Bankruptcy is a judicial declaration as to a debtor's financial status. The bankruptcy law has two definite purposes: to give the debtor a new start and to give creditors an equal chance in the collection of their claims. Any person or business may become a debtor except banks, insurance companies, savings and loan associations, and municipalities. Bankruptcy may be either voluntary or involuntary. A court will enter an order for relief upon the filing of an involuntary petition when the debtor is not paying debts as they become due, or a custodian of the debtor's assets was established within 120 days of the filing of the petition. Before debtors may file for bankruptcy, they must complete a 90-minute credit counseling session in the 6 months prior to filing. In a Chapter 7 case, the first step after a petition in bankruptcy is filed is to call a meeting of the creditors. The creditors elect a trustee to take over all the assets of the debtor. There is a special rehabilitation system for businesses so they may be reorganized rather than liquidated. If the debtor is an individual, a Chapter 13 plan in lieu of liquidation may be worked out. In order to file under Chapter 7, debtors must have current monthly income the same as or less than the median income of similar families. The federal law in every state set forth certain property that is exempt from seizure for the debts of the debtor. Some property acquired by the debtor after the start of bankruptcy proceedings may be used for the payment of creditors. The debtor must cooperate fully with the trustee. A reclamation is a claim for specific property held but not owned by the debtor. Claims are classified as fully secured, partially secured, and unsecured. If the debtor cooperates fully with the court and the trustee in bankruptcy and meets all other requirements for discharge, the application will be granted. Most important among the debts that cannot be discharged for bankruptcy are claims for alimony and child support, taxes incurred within 3 years, debts owed by reason of embezzlement, debts due on a judgment for malicious injury to others, wages earned within 3 months of the bankruptcy proceedings, deposits left with the debtor in a fiduciary capacity, and educational loans. Let's do our chapter review questions. Chapter 40, question 1. Why is a trustee appointed in bankruptcy case? A trustee is appointed in bankruptcy cases to pay each creditor in proportion to a claim to achieve a more equitable settlement. This arrangement promotes equity, wastes fewer assets, and costs less money than for each creditor to separately sue the debtor. Question 2. What are the different impacts on debtors that the various chapters of the Bankruptcy Code have? The different impacts on debtors that the various chapters of the Bankruptcy Code have are as to what property is taken, how long the bankruptcy supervision lasts, and who runs the debtor's business. Question 3. Who may file a voluntary petition with the bankruptcy court? Anyone except banks, insurance companies, savings and loan associations, and some municipalities can file a voluntary petition with the bankruptcy court. Question 4. What automatically happens when a bankruptcy petition is filed? When a bankruptcy petition is filed, there's an automatic stay in the filing for continuation of proceedings against the debtor that could have been begun or were to recover a claim against the debtor that arose before the bankruptcy petition was filed and it prevents a creditor from exercising control over property in the debtor's estate. Question 5. In order to get their debts excused, what counseling must debtors complete? In order to get their debts excused, debtors must complete a 90-minute credit counseling session in the 6 months prior to filing, and additional counseling on personal financial management after the bankruptcy case is done. Question 6. After a Chapter 7 case is filed, what must the creditors do? After a Chapter 7 case is filed, the creditors must meet and elect a trustee who takes over all the assets of the debtor. Question 7. What procedure may be followed rather than liquidating a business that cannot pay its debts as they are due? A reorganization proceeding is an alternative to liquidating a business. Question 8. If, under a Chapter 13 plan, all debts may not be fully paid, but a debtor is fully released from debts, why would creditors prefer that a debtor proceed under Chapter 13 rather than Chapter 7? While under a Chapter 13 plan, all debts may not be fully paid by a debtor is fully released from the debts, creditors would prefer a debtor proceed under Chapter 13 rather than Chapter 7 because they are likely in the long run to receive a greater percentage of the money owed them. Question 9. What property acquired by the debtor after the bankruptcy proceedings have been instituted is included in the debtor's estate? Property acquired by inheritance, divorce, or as a beneficiary of life insurance within 180 days after the date of filing is included in the debtor's estate. Question 10. If the debtor holds bailed property, must this property be included in the debtor's estate to pay creditors? If the debtor holds bailed property, the owner is not technically a creditor of the debtor. The owner should file a reclamation claim for the specific property so that it may be returned. Chapter 41, Nature of Real Property. Real property consists of land, timber, minerals under the soil, buildings, and all permanent attachments to the land, such as fences, walls, and other man-made property. Trees, orchards, vineyards, and perennial crops, such as clovers, grasses, and others that are growing on the land, are classified as real property. If a non-navigable river flows through a person's land, that person owns the riverbed, but not the water that flows over the riverbed. Personal property attached to a part of land is known as a fixture. More than one person can own real property. Common ways include a tenancy in common, which allows each owner to determine who gets the interest upon death, a joint tenancy that gives the remaining owners the deceased share, a tenancy by the entirety that is like a joint tenancy for married couples, and community property that presumes property acquired by a husband and wife during their marriage is owned separately and equally by each. An estate in fee simple is the largest and most complete right that one may possess in property. A life estate is the right to use property for life. The owner is called a life tenant. At the death of the life tenant, title passes as directed by the original owner. An easement is an interest in land, such as a right-of-way across another's land, like a driveway, or the use of another's driveway. A license is a right to perform certain acts on the land, but not to stay in possession of the land. Real property, but not personal property, can be acquired by accretion, which is the addition to land as a result of the gradual deposit by water of solids. Think of a sandbar. Adverse possession for the statutorily required period gives the possessor title to real property. Let's go over our chapter review questions. Question 1, give 3 examples of real property. Examples include land, the actual soil, all permanent attachments to the land, like a barn or a house, including fences, walls, timber, buildings, minerals under the soil, and waters on it. Question 2, what types of vegetation are normally considered real property? Normally, trees growing on the land, orchards, vineyards, and perennial crops, such as clovers, grasses, and others not planted annually and cultivated, are classified as real property until severed from the land. Question 3, what questions are asked to determine whether personal property has become a fixture? To determine whether personal property has become a fixture, a court may ask, how securely is it attached? What was the intention of the one installing the personal property? What is the purpose of the attachment? And who attached the item? Question 4, what are the different ways in which multiple people may own one piece of real property? The most common forms of multiple ownership of real property are tenancy in common, joint tenancy, tenancy by the entireties, and community property. Question 5, what specific portion of a property does any single tenant in common own? A tenant in common does not own a specific portion of the land. Each of the tenants in common owns an undivided fractional share of the property. Each has an interest in the entire property, but only to the extent of his or her percentage interest. Question 6, does a person who owns property in a joint tenancy determine who owns the property at death? A person who owns property in a joint tenancy does not have the power to determine who owns the property at death, because the remaining joint owner or owners automatically own the entire property. Question 7, in states that recognize community property, what specific language or actions are required for a married couple's property acquired during the marriage to be considered community property? In a community property state, no specific language or action is required for a married couple's property acquired during the marriage to be considered community property. Property acquired by either spouse during the marriage is presumed to be community property, absent specific agreement to the contrary. Question 8. What right to use land does an easement give a person? An easement gives a person a right of permanent, intermittent use of land. It does not give an exclusive right to possession. Think of a driveway. Question 9. Does a license give a person the right to possess land? No. It is a right to use property for a specific purpose and not to stay in possession. Think of a hunting lease. Question 10. How must a person occupy another's land in order to acquire it by adverse possession? One must occupy another's land in a continuous, open, hostile, visible, actual, and exclusive manner in order to acquire it by adverse possession. Chapter 42, Transfer of Real Property. The most common way of transferring title to real estate is by sale. Usually there will be a contract of sale followed by delivery of a deed. A deed is a writing signed by the seller conveying title to real property. There are two principal types of deeds. A quitclaim deed. In a quitclaim deed, the grantor gives up any claim to the real property. And a warranty deed. A warranty deed not only covers the grantor's interest in the real property, but in addition makes certain warranties. Unless statutes provide otherwise, a deed usually has the following characteristics: parties, consideration, covenants, description, signature, and acknowledgement. A deed is ineffective until it has been delivered. A deed need not be recorded in order to complete one's title. Recording the deed protects the grantee against a second sale by the grantor and against any liens which may attach to the property while it is still recorded in the grantor's name. The abstract of title gives a complete history of the real estate. It also shows whether or not there are any unpaid taxes and assessments, mortgages, or deeds of trust still outstanding, and any unpaid judgments or other unsatisfied liens of any type against the property. Title insurance may be purchased to protect a real estate buyer from a defect in title. Chapter review questions. Question 1. When is title to real estate transferred? Title to real estate is transferred when the owner delivers a deed to the buyer. Question 2. What is the inherent risk in accepting a quitclaim deed for property? In a quitclaim deed, the grantor only gives up what interest he or she has in the real property. The grantor may not have any interest to give, so the grantee might end up with nothing. Question 3. What is the difference between a general warranty deed and a special warranty deed? A general warranty deed warrants that all prior grantors had good title and that no defects exist in any prior grantor's title. A special warranty deed only warrants that the grantor has the right to sell the property. No warranties are made regarding prior grantors. Question 4. What are 6 necessary elements in a deed? A deed should contain the name and marital status of the parties, a statement of consideration paid, any necessary covenants, a correct description of the property, the signature of the grantor, and an acknowledgement. Other state law requirements may include addresses of the parties or additional witnesses. Question 5. Why might a deed not cite the actual consideration paid? The parties might not cite the actual consideration paid in order to keep the actual sales price from becoming a matter of public record. Question 6. What is an acknowledgement and why is it necessary? An acknowledgement is a declaration by the properly authorized officer that the grantor has acknowledged signing the instrument as the grantor's free act and deed. An acknowledgement allows a deed to be recorded. Recording also raises the presumption of delivery of the deed. Question 7. How is a deed delivered? The grantor must relinquish control and lose the right to demand its return. Question 8. What is the purpose of recording a deed? Recording is not required in order to complete transfer of title, but recording protects the grantee against a second sale or future liens against property of the grantor. Question 9. What is an abstract of title and what is its significance when transferring real estate? An abstract of title is a history of all transactions involving a piece of real estate. Before real estate is purchased, it is advisable to have the abstract examined to see if there are any unsatisfied liens against the property. Question 10. Explain who is benefited by title insurance. Title insurance benefits the owner of real estate but it does not benefit a subsequent purchaser or a mortgage. Chapter 43, Real Estate Mortgages. A mortgage is a lien given upon real estate to secure a debt. The mortgage contract sets forth the rights and duties of the contracting parties. A mortgage should be recorded immediately in order to protect the priority of the mortgagee. The duties of the mortgagor include to pay the principal and interest as the payments fall due, to pay all taxes against the real estate and all assessments, and to keep the security of the mortgagee unimpaired. The rights of the mortgagor are to receive possession of the property, to receive and retain all rents and profits from the property, to have the lien canceled upon final payment of the mortgage, to redeem the property when all statutory requirements for redemption have been met, and to sell the property. A purchaser may buy property by agreeing to assume the mortgage, that is, by being bound on the mortgage obligation as fully as the original mortgagor. If the property is taken subject to the mortgage and default occurs, the buyer may lose the property, but no more. If the mortgagor fails to pay the debt secured by the mortgage when it becomes due, or fails to perform any of the other terms set forth in the mortgagee has the right to foreclose for the purpose of collecting the debt. The mortgagee may assign the rights under the mortgage agreement. A deed of trust is often used as a substitute for the ordinary form of mortgage for the purpose of securing a debt. Private companies and several agencies of the federal government insure or guarantee mortgages against default by the mortgagor. Let's review our chapter review questions. Question 1, how is a mortgage different from a debt? A mortgage is not a debt itself, but rather an interest in real estate given to secure the payment of a debt. Question 2, what formalities are necessary for a mortgage? The formalities necessary for a mortgage are a writing, acknowledgement, and setting forth the rights and duties of the contracting parties. Question 3, explain the purpose for which a mortgagor may execute a mortgage. Normally, a mortgagor executes a mortgage to raise money for the purchase price of real estate, but one can borrow money for any reason and secure the loan by a mortgage. Question 4, what duties does a mortgagor assume? The duties of a mortgagor assumes are payment of interest, principal, taxes, assessments, and doing nothing to impair the security of the mortgagee. Question 5, what rights does an acceleration clause in a mortgage give the mortgagee? An acceleration clause in a mortgage gives the mortgagee the right to declare the entire principal immediately due if the mortgagor does not make an interest or principal payment when due or within a specified time after due. Question 6, what rights does a mortgagor retain? A mortgagor retains the right to possession of the property, rents and profits from the property, cancellation of lien upon payment, redemption of the property after a foreclosure sale, and sale of the property. Question 7, what must a mortgagor do to redeem property after default? To redeem property after default, the mortgagor must pay the amount of the mortgage, the cost of the sale, and any amounts paid to protect the purchaser's interest in the property, such as taxes or insurance. Question 8, what does it mean to assume a mortgage? When a purchaser of property agrees to assume a mortgage, she agrees to be primarily reliable for its payment. A mortgagor will also remain liable for payment unless the mortgagee agrees to a novation. Question 9. What is a mechanic's lien? A mechanic's lien is a lien held by people who have furnished materials for or workers who have worked on construction of a building. Question 10. What government programs are available to assist people obtaining a mortgage? The most frequently used programs are those administered by the Federal Housing Administration, the FHA, and the Veterans Administration. Specific requirements for these programs may be found on their respective websites. Chapter 44, Landlord and Tenant. The relation of landlord and tenant is created by a contract whereby one person agrees to lease land or building to another. The owner of the property is known as the landlord or the lessor. The person who is given possession of the property is the tenant or the lessee. The contract between the landlord and the tenant is called a lease. The lease may be oral or written, express or implied, formal or simple, subject, however, to statutory requirements that a lease of land for a term of longer than 1 year must be in writing. There are 4 separate and distinct classes of tenancy. A tenancy for years is any tenancy for a definite period of time. A tenancy from year to year is a tenancy for an indefinite period of time with rent set at an annual amount. A tenancy at will exists when the tenant has possession of the property for an uncertain period of time. And a tenancy at sufferance exists when a tenant extends the tenancy after the expiration of the lease without permission of the landlord. A lease gives the tenant certain rights as follows: the right to possession, right to use the premises, the right to sublease. Duties of the tenant are as follows: to pay rent and to protect and preserve the premises. The landlord has 3 definite rights under the lease: the right to regain possession of the premises, to enter upon the property to preserve it, and to assign rights. The lease imposes upon the landlord certain duties: the duty to pay taxes and assessments, to protect the tenant from concealed defects, to mitigate damages upon abandonment by the tenant. A lease for a fixed period terminates at the end of that time. Giving the statutory notice to vacate terminates a lease for an indefinite period of time. Tenants frequently make improvements during the life of the lease. When disputes arise, the test to determine whether the tenant may take the improvement is whether the improvement is temporary or permanent. Let's go over our chapter review questions. Question 1. What formalities are required to create a lease? No special words or acts are required unless the lease lasts for more than a year, in which case it must be in writing. Question 2. What is the difference between a tenant and a lodger or roomer? A tenant differs from a lodger or roomer in that the tenant has the exclusive legal possession of the property, whereas a lodger or roomer has merely the right to use the premises subject to the control and supervision of the owner. Question 3. What guidance is available to courts attempting to resolve a dispute between a landlord and a tenant? The court must look first to the terms of the lease, if any, and then the general body of landlord and tenant law. To avoid uncertainty, leases should be thorough and in writing. Question 4. Does a lease without a definite set time period last forever? A lease without a definite set time period is a tenancy from year to year or month to month, and is determined by the nature of the rent stated or paid. Question 5. What are a landlord's options when the tenant holds over? A landlord may either treat the tenant as a trespasser and sue for damages, or accept the tenant's payment for rent. Question 6. What is the difference between an assignment of lease and a sublease? An assignment includes the entire premises, and the assignee pays rent directly to the landlord. A subtenant may lease only a portion of the premises or a portion of the time. Generally, a subtenant pays rent to the tenant, who then pays the landlord. Question 7. Explain the duty of a landlord to mitigate damages. The landlord's duty to mitigate damages means that if a tenant abandons the premises before the end of the lease term, the landlord must try to secure a new tenant. Any damages the original tenant owed will be reduced by the amount of rent paid by the new tenant. Question 8. If the tenant moves out of leased premises before expiration of the lease, is the lease terminated? If the tenant moves out of the leased premises before expiration of the lease is terminated only if the landlord agrees to termination. If the landlord does not consent, there will be a breach of contract. Question 9. If a tenant refuses to give up possession after the expiration of a lease, what may the landlord do? If a tenant refuses to give up possession after the termination of the lease, the landlord may seek an eviction of the tenant. Question 10. What must a tenant remove from the property at the end of the lease? Personal property that has not become a fixture, trade fixtures which can easily be removed without substantial injury to the property, and any items specifically designated in the lease must be removed by a tenant at the end of the lease. Chapter 45, Wills, Inheritances, and Trusts. A will is an instrument prepared in the form prescribed by law that provides for the disposition of personal property to take effect after death. The restrictions placed upon the right to dispose of property by will are as follows. One cannot deprive a spouse of a statutory right in the property. In some states, one cannot control by will the distribution of property in perpetuity. Terms common to wills. A testator or testatrix is the person making the will. A devisee is the one receiving a gift of real estate. A legatee is one receiving a gift of personal property. A device is real property given by a will. A bequest or legacy is a gift of personal property. An executor or executrix is a person named in a will as the one to administer the estate. One who dies without having made a will is said to die intestate. An administrator or administratrix is a person appointed by a court to settle the affairs of an intestate. A will has the following characteristics that distinguish it from other legal instruments. The courts construe a will with less technical strictness than a deed or other written document. A will devising real property must be executed in conformity with the law of the state which the property is situated. A will bequeathing personal property is governed by the law of the state in which the testator was domiciled at the time of death. A will may be revoked at any time during the life of the testator. All states prescribe certain formalities that a will must meet. These formalities must be strictly adhered to. Some special types of wills are holographic wills, those written entirely in longhand by the testator, and non-cupative wills, those that are made orally during an emergency. The wording of a will should be clear so that it will be interpreted exactly as the testator included or intended. A codicil is a separate writing that modifies a will. A will may be revoked any time prior to the death by the testator by destruction or alteration, marriage and divorce, execution of a subsequent will, and after-born child. An redemption exists when a testator bequeaths an item to a party and the item is not in the estate at the testator's death. When the testator dies leaving a will, the will must be probated. With but few exceptions, anyone may be appointed by the testator to serve as an executor of the will. If an individual owns no property at death, there is no need for administration. When a person dies intestate, the property is distributed in accordance with the state law of the decedent. If the testator's children are living at the time of the testator's death, and the spouse is also dead, the property will be distributed per capita or equally by head among the children. Property is said to be divided per stirpes if one child predeceased the testator and left surviving children, in which case the deceased child's share of the property would be divided into equal parts, with one of these parts going to each of the grandchildren. The law sets forth an order of priority for the appointment of an administrator. Administrators must also post a bond. The prime duty of an executor or an administrator is to preserve the estate and distribute it to the rightful parties. A trust is a form of contract by which one person or entity agrees to hold property for the benefit of another. Frequently used types of trust include express trust, resulting trust, constructive trust, blind trust, and testamentary trust. Let's go over our chapter review questions. Question 1. In order to make valid wills, people must have the mental capability at the time of making a will to know the natural object of their bounty, understand the nature and extent of their property, understand that they are making a will, and have the ability to dispose of their property by means of a plan they have formulated. That's the answer to question 1, which asks, what capacity must people have in order to make valid wills? Question 2, what are 2 common restrictions on the rights to dispose of property by will? 1, the right of a spouse to set a portion of all the property the decedent owned. And 2, in some states, one cannot control by will the distribution of property for all time, meaning into perpetuity. Question 3, what happens if all the prescribed formalities are not followed in executing the will? If all the prescribed formalities are not followed in executing a will, the court may disregard it, and the testator's estate may be disposed of in a manner entirely foreign to the testator's wishes. Question 4, what is the difference between redemption and abatement? An redemption occurs when a testator makes a bequest of a specific property, but the estate does not own the property at death. In this case, the intended bequest has no meaning and no substitution is made. An abatement occurs when the testator makes bequest of money, but the estate does not have enough assets to satisfy them all. Each legatee will receive a proportionate share. Question 5. What is probate? Probate is the court procedure that determines the validity of a will. Question 6. What if no beneficiary survives to inherit an estate? At some point in its line of succession, every state has a limit beyond which no more beneficiaries will be sought and property passes to the state. Question 7. What is the difference between distributing property per capita and per stirpes? Per stirpes distribution would be required if a child predeceased a parent who died intestate. That child's share would then be divided equally among any children of that child, the grandchildren. If an intestate leaves 3 living children and no spouse, the property is distributed per capita or in 3 equal parts. If one child predeceased the intestate and left 2 children, the property is distributed per stirpes. That is, 1/3 will be equally divided between the deceased child's 2 children. Question 8. What is the primary duty of an administrator and how does it differ from that of an executor? The prime duty of administrators is to preserve the estate and distribute it to the rightful parties. It does not differ from the prime duty of executors. Question 9. What ownership interests of property are divided by the establishment of a trust? The establishment of a trust divides at the same time the legal ownership and the beneficial ownership of the property. Question 10. What formalities must be followed to create a testamentary trust? Because a testamentary trust is created by will, all the formalities of creating a will must be followed in order for the trust to be created. Please email me the answer to the last question in chapter 45.